Good afternoon, Your Honor.
This is 213999 LT Bellevilla Meadows versus Justin Awad. State your name for the record, please, sir.
My name is Justin Awad.
Thank you. Sir, today is the day and time scheduled for the adjourned trial in this matter. We started taking testimony in this matter back on October 6, 2021. There were some issues that came up at that date when we concluded our hearing and we adjourned the matter until October 15th. October 15th came, the plaintiff's attorney failed to appear. We adjourned the matter to October the 18th. On October the 18th, we took a status of the matter. Management had been in the unit and contracted with a roofer. We adjourned the matter for about 3 weeks. And there was an issue that had come up regarding the filing of a lawsuit in circuit court regarding the same parties. There was an order for escrow entered and the defendant started paying escrow in this matter. Came to the November 16th date and we again adjourned this case till today. It was going to be more, the contractors needed more time to do the work that had been discussed and agreed by and between the parties. We'd had conversation regarding the SARA payments that came that had not been, that were showing late payments but weren't really late payments. It was a SARA payment. We had a conversation regarding dogs in the unit beyond the number of dogs allowed in the rental agreement. And the parties were encouraged to work towards a resolution. In any event, we are scheduled to resume and conclude trial today at 12 o'clock. It's 12:18 by the court's clock. My secretary advised that you logged on timely and ready to proceed in this matter. Mr. Landau is not in this court's virtual waiting room or the court's virtual courtroom. How do you wish to proceed, sir?
What are my options?
I can't give you legal advice or assistance in this matter, Mr. Awad, and I'm not sure of what conversations or what negotiations you had with Bellevilla since we were last here.
So as of last week, Mr. Landau and I had signed a motion to dismiss because
I'm sorry, you signed a dismissal of this case?
I did, yes, and so did Mr. Landau. I submitted documentation showing that 2 of the dogs are therapy dogs, and so that no longer gave them a pet status. So that was no longer an issue.
I don't see a dismissal in the court file. And the last entry that I have is from December 29th. But you indicated that you signed the dismissal and Mr. Landau has signed it, or did you sign it and send it back to him?
I signed it and sent it to him.
It had his signature on it.
And it had his signature on it.
Okay. The court does not have it as of yet, but what I will do is based on your indication to the court and the fact that Mr. Landau is not here, I'll make an entry in the file that the parties have signed a dismissal.
I have a screenshot of it here if you want it, Your Honor.
That'd be great. Thank you.
Yeah, let me share my screen. Right here. And then his signature at the bottom left and mine at the bottom right.
Thank you, Mr. Awad. If you would be so kind, I am going to put a email address in the chat. It's for the civil department. If you would send that over to them, they'll get it up to me and I will sign it. And I'll consider the matter resolved.
Okay.
Other than the dismissal, is there anything, does the dismissal speak to the escrow?
I believe it asked to release the money to Mr. Lando's office. Yes, escrow is
Okay.
released payable to plaintiffs and mailed to plaintiff's attorney.
Thank you. I'll walk downstairs and get the dismissal. If you email it over, I'll get it from the civil department. I'll sign it and it'll go out to the parties.
Okay, I'll email it to you right now.
Anything else in this matter, sir?
I don't believe so. I think
Okay,
now we can proceed to the circuit case.
which I don't want to know anything about, but what I will do is, thank you for logging on this afternoon and clarifying this dismissal. I will walk downstairs myself right now and see if I can grab it from the civil department and get it signed today and on its way out to the parties, okay?
All right, thank you, Your Honor.
Thank you, sir. Have a good afternoon.
You too.
Bye-bye. This is 215088 GC LVNV funding versus Cal Abradovic.
Good afternoon, Your Honor. Preston Nate, P77884, appearing for LVNV funding.
Good afternoon, Your Honor. Socorro Henry, P65526, appearing on behalf of Kyle Abradovic.
Good afternoon. Today is the date and time set for the first pretrial in this matter. Mr. Nate, how are we proceeding this afternoon?
If it's okay with Ms. Henry, I think we'll probably just proceed with a scheduling order, probably 60 to 90 days discovery. We usually do get these worked out. Doesn't look like we've had a chance to really do that quite yet, but I think 60, 90 days discovery should be fine, and then we can go from there.
60 days discovery starts today, closes March 7th, 2022. This matter will be scheduled for a final pretrial on April 5th, 2022 at 10:15 a.m. Any motions must be filed and heard by that final pretrial date. Trial date will be, live trial will be April 29, 2002 at 11 a.m. So again, 60 days discovery closes March 7th. Final pretrial, April 5th, 2022 at 10:15 a.m. by Zoom, back courtroom number 1. All motions must be filed and heard by that date, and a live trial date, bench trial date of April 29, 2022 at 11 a.m. Mr. Nate,
Your
if you
Honor.
will prepare an order with those dates and deadlines. Anything else on behalf of the plaintiff?
No, I think that's it for now.
Anything else on behalf of the defendant, Ms. Henry?
No, Your Honor. Thank you.
Thank you so much. I'll see you all on April 5th.
All right, thank you. For
This is 213740 GC, Teresa Butler versus Delta Airlines. May I have your appearances, please?
Tim O'Connell appearing on behalf of the defendant and movement Delta Airlines, Your Honor. Good afternoon.
John Ivanchik on behalf of the plaintiff. Sorry, I'm used to being on the other side, so I guess I should have gone first, but that's okay.
Thank you. Today is the day and time set for the defendant's motion for summary disposition. I have reviewed both the motion and the response. Mr. O'Connell, your argument, please, sir.
Knowing that the court has read the papers, Your Honor, I'll keep my comments very brief and obviously be available to answer any questions that you may have. From Delta's perspective, Your Honor, this is a very straightforward summary disposition as articulated in the motion and as spelled out specifically in the contract of carriage attached to the motion. Delta has a specific provision in its contract of carriage, which is allowed under federal law, that provides for certain claims restrictions, and specifically articulated in those terms is an exclusion of any responsibility or liability for any jewelry that may be carried in checked or unchecked baggage. And we articulated again both the federal aviation regulation that allows for that limitation, as well as the underlying policy reasons for it provided by the Department of Transportation. And in this case, we have the plaintiff who claims that she had some jewelry in her baggage she was intending to carry on, and she was forced to gate check that bag instead. And while the bag was gate checked, some jewelry allegedly went missing. And Delta's position is that whether she carried the bag on or whether the bag was checked under the provisions of the contract of carriage, and again, as allowed by federal law, Delta is not liable for the jewelry specifically. And therefore, Delta would be entitled to summary disposition under MCR 2.116 C8 and or C10, since there was no question of material fact that the jewelry was in fact contained in plaintiff's bag. And with respect to the balance of the $5,000+ that plaintiff is seeking, to the extent that any of that represents losses for any items that were not jewelry, again, as articulated in the motion and supporting affidavit, Delta did provide over $800 to plaintiff to account for any such losses. And therefore, Delta is also entitled to summary disposition under MCR 2.11 C7. And again, knowing that the court has reviewed the motion and the exhibits, we'll from that point rest on our briefs and ask the court to grant the motion and dismiss plaintiff's claims with prejudice. Thank you, Your Honor.
Thank you. On behalf of the plaintiff.
Thank you, Your Honor, and I'll try to keep mine brief as well. This case just really boils down to whether Delta can avoid responsibility when for my client's stolen items when she was forced to give up her bag at a gate check after she had gone through security, after she was afforded an opportunity to obtain traveler's insurance or what have you. And I don't believe that that is the case. I stated in the responsive brief that I filed here is that there's a difference between a check bag and a gate check bag. This is a gate check bag. This is a bag that never left Delta's control after my client turned over possession versus a check bag. Check bag goes through security. It goes through TSA, which is and a check bag is one that you would get at the curb or prior to going through physical security, the body scanners and all that. The TSA handles all the screening for those kind of bags. This had already gone through in my client's possession or while she was going through the security in a carry-on. And it wasn't until she went to board the aircraft that she was told that she could not take this carry-on on because there was insufficient space. That's not her fault. It's not anything that she planned on. It was simply the Delta telling Delta's employees telling my client, you don't have a choice. You have to put it in our possession, and that's it. You have no other remedy, no other opportunity to do anything. This is it. So with that being said, the policy that they cite here does not appear to apply to gate check bags, and there's nothing specifically stated in gate check or about gate check bags within their policy, but their website does recognize the difference between the two. And we pull all the other stuff on here from their website. So I don't see why it's misleading at the very least, but there's a difference between a gate check bag and a check bag. And a gate check bag is one that doesn't leave, or once you hand it over to Delta, the bag stays within Delta's control versus check bag, which leaves Delta's control. So I don't see that there's an exclusion here. I don't see that there's anything within the exclusion that provides for a gate check bag. And that was what my client had. The other kind of argument here, I think that they made is that my client didn't respond or make a claim of lost or stolen items within the time frame. I pointed out in the motion here that the contractual part that the contractual clause that they cite actually has two different notification requirements. Any notification within 24 hours or written notification within 21 days. It's very different than some of the other airlines that I looked at, JetBlue being the one specifically that I cited, where JetBlue requires notification, I think by any means within 4 hours and then 21 days written confirmation. It uses the word confirmation, whereas Delta uses the word notification. And my client did, without any question, notify Delta within 21 days that she had suffered a loss. Actually, she did within we'll say 36 hours, I think it's safe to say. It was written by email. So I don't believe that there is still a genuine issue material fact here, Your Honor, as to whether or not there's a difference between a check bag and a gate check bag that the plaintiff has cited here. In terms of the contractual notice period, I believe, again, there's obviously an ambiguity, there we go, between what the Delta contract says, providing for two different notification timeframes. And with regards to the amount, I do believe federal law does allow Delta to limit their damages in the event of lost or stolen items to $3,800. It's good to see that Delta is doing the bare minimum under federal law. So for those reasons, I would ask that the court deny the motion at this time.
Thank you. Mr. O'Connell, anything else?
Just very briefly, Your Honor, and again, to reiterate the exact language that's used by Delta. Delta is not responsible or liable for jewelry contained in checked or unchecked baggage. So again, whether it was in a carry-on bag, a checked bag, or a gate checked bag, the result is the same. Delta is not liable or responsible as a matter of law. And again, there's no question of fact that the jewelry was in a bag. So for that reason, Your Honor, Delta would again request that the motion be granted and summary disposition be entered in its favor. Thank you, Your Honor.
Thank you. As indicated, the court did take the opportunity to read the motion and the responses. I read the motion when it came in back in October and have questions and still have questions. The basis for the defendant's motion was first, payment, a C7. No one's produced a copy of the check. No one's even asserted that Ms. Butler, in fact, negotiated the check. So the court had questions about whether or not payment was really at issue. C8, that the plaintiff had failed to state the claim on which relief can be granted. I think the plaintiff made a good statement, not necessarily a very thorough statement, but made a clear statement as to the basis of her loss in her original small claims affidavit. And then you have the C10, sufficiency of the claim. Again, the court still has some questions about the exact claim that the plaintiff made. No one's attached a copy of the claim. So although there's an assertion that Ms. Butler has a loss of some almost $6,200, I haven't seen in either the attachment to the motion or the response what exactly Ms. Butler is alleged to have lost. There's reference to certain pieces of jewelry, and then it says other non-jewelry items. And so saying all that to say that the court believes that the motion for summary disposition is premature, at least in part. There are some issues, there are some questions that still remain. For that reason, the court is going to deny the motion for summary disposition. And as for the balance of the case, I don't think that there had been an actual pretrial conducted where there was any discovery ordered or any other next steps. So on behalf of the plaintiff, for moving forward, how do you wish to proceed, sir?
If the court deems it necessary to do discovery, it really depends upon what the defendant wants. Otherwise, I would ask for case evaluation. I think that'd be appropriate in this case.
It's not what the court wants, it's what the parties wants. I don't care if you say you want to try. If you say you want a trial, I'll schedule the trial right now. If you
No,
think-
Your Honor, yeah, that'd be fun. No, I think case evaluation is probably the best thing to do in this situation. And anytime that the defendant needs discovery wise, I'm sure that I'm sure they want some time, but I don't really have an objection to that.
Mr. O'Connell?
Your Honor, I guess in short, I'd like to confer with my client as to what direction they want to take in the case going forward. I'm not sure whether any discovery would be warranted or not. Again, my understanding is that Delta paid, and based upon the affidavit attached to the motion, Delta paid the $800-something to plaintiff. That attestation, by the way, was uncontroverted by any evidence. But that said, I think the balance of what she's claiming, whatever that number may be, was in fact jewelry. And again, that was uncontested by plaintiff. So I'm not sure what discovery would be needed as to which items were specifically missing as alleged by plaintiff, but certainly there's a possibility of some discovery there. But other than that, I'm not sure what's left to be had in terms of discovery going forward in the case. And obviously, like I articulated in the argument, the C8 basis for the motion was the contract of carriage, that there's no discovery to be had there. The contract says what it says. And of course, the construction of that contract is a question of law for the court rather than a question to be on any sort of facts that would be developed in discovery.
Sir, if
yes.
it doesn't sound like plaintiff wants discovery, you don't want discovery, that's fine. Plaintiff has said they'll request case evaluation. Do you object to case evaluation?
In principle, no, Your Honor. But like I said, I would like the opportunity to first confer with my client about any discovery that they may feel they need, whether for going forward in the case or for case evaluation with respect to any, unitemized issue, any items that were missing that are not accounted for in, like you said, the sort of broad allegation of the $5,000 or $6,000 of missing items. So again, whether we can account for that to the penny or not based upon the information we have, I can't speak to that. So to that extent, there may be some discovery necessary. But that said, in principle, we're not adverse to case evaluation where there's a possibility of sorting it out there as well.
Okay.
So maybe if it helps, Your Honor, why don't we just set it for case evaluation? And if counsel needs additional discovery, we can stipulate to that. Just move the dates out for case eval. Does that work? After he's talked to his client?
Since both of you seem reluctant to do discovery, and I'll say that and leave it right there for right now. My
Okay.
note in the file is just going to be that the motion for summary is denied, and if plaintiff would submit an order to that effect, number one. Number
Okay.
two, case evaluation as requested by plaintiff's attorney, and the civil department will prepare an order unless you want to do it. Doesn't matter to me. I'll have the civil department prepare an order to send the matter to case evaluation. And then I'm hesitant to set a date close by. I don't know how far out they're doing the case evaluations. We can put a control date in. I can put you on the April 5th docket of mine at 10:30. And hopefully you will have completed the case evaluation by that point. And if you haven't, let the civil department know, and we can push that date out, but we'll call that April 5th date. I think technically it would be the pretrial, which seems kind of.
That works for me, Your Honor. And I'll submit an order for opposing counsel's approval. We'll submit it to the court and we'll look for the case evaluation order.
Thank you. April 5th at 10:30 for the pretrial. If anything comes up between now and then, the parties resolve the matter or need to get back on, just let us know. Otherwise, I will see you back here on April the 5th.
Thank you, Your Honor.
Thank you, Your
Thank you,
Honor.
Your Honor.
Anything else on behalf of plaintiff?
No, Your Honor.
Anything on behalf of defendant?
All set for today. Thank you, Your Honor.
Thank you so very much. Everyone have a good afternoon. Thank you.
You too.
Thank you, Your Honor.
Thanks.
Bye.
Mary Ann, any chance that 2 o'clock will get here early?
Yes, I'm hopeful.
Got it.
Make that window bigger of the black one.
Yeah, yeah.
Yeah. And he says, oh, I said, yeah, so we can get him to 6,500. I said, at least it gives you some kind
Mhm.
of bird in the hand.
That's right.
Hey, John, just, you're still not on mute.
Okay, where am I here? Here we go.
This is 210787 LT Mohammed Musa versus Jose Arcos Nava and Miriam Juarez. May I have your appearances, please?
John Brandt on behalf of plaintiff.
Edward Drugas for the defendants.
Thank you. Today is a day and time set for the settlement conference in this matter. Mr. Britt, how are we proceeding this afternoon?
Well, Mr. Drukas and I had spoke earlier regarding settlement, and we were fairly far apart. I just sent Mr. Drukas, and I'm not sure if he received it, an email. I had spoken to my client who was willing to come down considerably from where he was. So, you know, we're attempting to reach an agreement on settlement. And so that's where we are now. Mr. Drukas had some questions about procedure and about briefing.